run-of-style violate international law by issued their regulation and thus obligate to compensate the economic losses that run-of-style has caused. Your Excellencies, I bring two arguments. The first, run-of-style violate international law by did not report to the WHO immediately and discriminated appropriate with their anti-regulation and travel restriction. The second point, run-of-style must compensate the economic losses that run-of-style has caused to appropriate. If you don't mind the structure and make this the court.
Yes, please.
This issue emerged when run-of-style made the entry regulation and travel restriction regarding on the JVID Act and pandemic, and put Aprilia on their high-risk countries list, while in Aprilia only have 9 confirmed cases. This is run-of-style assumed fraud to the action because to prevent their citizens from the virus, but on the other hand, that gave unsavory effect to Aprilia's economic, especially in the tourism sector. Hence, this is the pioneer why run-of-style violate international law and must compensate of it. Your Excellencies, run-of-style did not report to the WHO about their anti-regulation. This is contradicts with Article 63 in the WHO Constitution, stipulates each country has to report anything about law, regulation, and statistics in the health measure context promptly to the WHO. Yes, precisely in Article 3, Paragraph 4 of IHR, each country has their sovereign right to legislate and implement their legislation itself, according of their health policies, but still have to uphold and comply to the WHO and IHR, Your Excellencies. And this strengthened by the International Sanitary Convention, where everything that taken by a state, such as a statistic about plague or pandemic, they have to notify to the WHO first. Your Excellencies, regarding on the previous regulation, run-of-style did not report anything about their anti-regulation.
Is there any previous case that can be related as our case right now?
Yes, Your Excellencies, I understand your concerns. Since there's no case of it that, and the case is only stuck, such as in the case of Canada's action by cancel all the travelers visa over the travel restriction in Ebola outbreak, and then the WHO constitute Canada as a breach of the IHR and the global health efforts. Thus, this could be a new discovery in international law that order all states the who breach of IHR or WHO constitution to be referred to the ICJ and be the and has responsibility to give compensate to the injured country that touched by the impact of the first country, Your Excellencies. Because if extreme measure of a country is always happened in an outbreak case, it is probably support the country to injure other people or other country, Your Excellencies. Thus, we believe that run-of-style has violated international agreement and should be referred to the International Court of Justice as a consequence not honoring the WHO Constitution as laid down in the Article 75.
Is Canada revoke or revise any regulation pertaining the entry restriction of the IHR, or just continue to proceed their regulation?
Yes, Your Excellencies, after the WHO constitutes Canada of their action is excessive measure in the in the Ebola outbreak, thus Canada stop and void their extremely measure, which is travel all the visa of the traveler itself, Your Excellencies.
In your point of view, is our case is fulfill the requirements in the Article 43 of International Health Regulation from WHO or not?
Yes, Your Excellencies. In the case of between run-of-style and Aprilia, run-of-style not comply with the article of 43 in the IHR, which has to comply, which have to comprises with the public health measures, scientific principles and evidence, and WHO guidance and advice, and also avoid interference of the traffic and trade ban, and thus clearly not shown by run-of-style. And also in the Canada's action itself is clearly not shown, and Canada cannot prove that uh, that the country has complied with the Article 43 of IHR Excellencies.
Okay, Jun, you may continue your argument.
Thank you, Excellencies. Furthermore, this is excessive measure of run of style by put Aprilia on their high-risk countries list, while in Aprilia only have 9 confirmed cases. Based on the third section of run of styles regulation stipulates each country will add to that list if there's a 50 minimal confirmed cases. Thus, it means run of style also violate their own regulation because Aprilia at the time did not have a confirmed case of 50 suspect person of the JFIT Act in itself. And because of this, Aprilia has asked run of style with good faith to remove Aprilia from their high-risk countries list. But run of style still refused to do that, Your Excellencies. Hence, this is the tantamount not under the principle of good faith by run of style by did not want to remove Aprilia from the high-risk countries list. And subsequently, Ranov discriminated Aprilia with their anti-regulation and travel restriction. Your Excellencies, this is contradicts with Article 13 in Declaration of Human Rights, where everyone has right to living or enter any country. As known, 40% in Aprilia, except Ranov who want to travel at Apria's territory, they have to transit at Bokpade Airport, which is in Ranov territory. But in fourth section of Ranov anti-regulation stipulates each individual who transit at one of Ranov airport, they have to deem and follow this regulation. Thus, Ranov indirectly has limited Apria's rights as a country, which is in the economic aspect, who is the biggest vehicle income of the state itself, Your Excellencies. And furthermore, according to the travel bans, Ranov also violate Article 12 of ICCPR, where the freedom of movement that laid down in the United States World Tourism Organization is an important contribution vehicle for individual and also for the state. Your Excellencies, whether Aprilia that in Apria's territory or not, or Aprilia that not gain of the JFIT Act or not, they cannot gain their freedom to travel anywhere they want. And this is really contradicts with Article 1, 2, and 7 on Declaration of Human Rights, where all people must be treated equally, Your Excellencies. Especially the prohibition of entering or leaving any country without clear reason and lack of evidence is a form of a discrimination to Aprian. And if Ranov opt to strengthen their policies, why they don't do the test to detect the person that is gain of the JV vaccine or not by do the rapid antigen or PCR and not generalize or all Aprepulian as a danger. Your Excellencies,
Agent,
if
as
yes, Your Excellencies.
you stated that in the ICCPR it is one of the as the right of the applicants is treated equally, right? But I think the respondent has a territorial sovereignty, and it is makes sense if they can apply their uh, entry restriction as their territorial sovereignty.
Yes, Your Excellencies, I understand your concern. Indeed, Ranov has their sovereign right to make anti-regulation or travel restriction as a form of their sovereign of their country's sovereignty. But the state sovereignty also refers to Ranov obligation to respect the rights of other countries. This examine in limited sovereignty, which clarified by John Locke and Jeremy Bentham on the Book of Model Constitutionalism, where sovereign of the state is limited by another country or excellencies. Thus, what Ranam did, even they state to protect their citizen, they have the public interest or and so on, it is still a form of violation of international law because that gave unsuffered effect to Apria's economic excellencies. And this is strengthened by the Article 27 officiality, where no country can defend their own laws country as a justification of their failure to the international obligation, excellencies. May I proceed to the second point?
Yes, you may.
Thank you, excellencies. Ranov must compensate the economic losses that Ranov has caused to Aprepulia. This is under Article 40. This is under Article 43 of HR. All the WHO member in health measure context are prohibited to do the restrictive of international traffic. Thus, Ranov must compensate of 130 million euro as a form of responsibility to Aprepulia. Your Excellencies, under Article 31 in responsibility of states for internationally wrongful act, Ranopstoy has responsibility to give a reparation as the result of a travel restriction that affects an economic losses of Aprepulia. Thus, Aprepulia require the compensation based on the international wrongful act that covers any financially accessible damage, including loss of profits, both material and non-material, that went to the GDPs of Aprepia's tourism. The total 130 million through 30 June
Agent,
2019
agent,
until now.
uh,
Yes, Your
you use,
Excellency.
you use internationally wrongful act as your legal basis. Is that internationally wrongful act has a legal binding in both of countries?
Yes, Your Excellencies, I understand your concern. Consider the rules of internationally wrongful act is did not exist in international law. Thus, as a sources to the Article 38 of the ICJ statute in the international wrongful act context, ILC recognized as the only one sources that exist and relevant with all civilized nations, Your Excellencies. Thus, Run of Style has legally binding also legally binding to this international warfare.
Is that customary international law or general principle? Is that fulfill the requirement as the resources of international law?
Yes, Your Excellencies. The International Warfare Act is clearly fulfilled to the international law, and uh, internationally Warfare Act itself is a rule that is the only one rules that arrange about the action of the state that could be injured to the other party or consists. Thus, Ranov has an appropriate legally binding to this convention, to the ILC or consists.
Even if the internationally wrongful act is only or still a draft.
Sorry, Your Excellencies, can you repeat your question?
As we know that internationally wrongful act is still a draft, so it is still legally binding in both of the countries, even it is
Yes,
still draft.
yes, Your Excellencies. Even is it still a draft, but as is recognized with all international community to settlement the dispute between a country, then the International Warfare Act is only a draft. Is clearly has a legal basis to the ICJ statute or extensions. For instance, in the German court, an ICJ is also take the ICJ for the legal basis to judge the dispute in the court, your excellencies.
Okay, you may continue, agent.
Your excellencies, going to the second submission is regarding run of style violate international law by failing to hand over misconduct vermin to the appropriate authorities. Your excellencies, may I bring on the table two arguments. The first action to accept misvermin by run of style's consular is indeed violating international law. And the second, misconduct vermin is not fit with the criteria to be called as asylum or refugee seeker. If you don't mind to the structure, I could proceed the second submission.
Yes, please.
This issue appear when there is one of the employee in the NBL named Ms. Kemba Verman reported about the cases of COVID-19 with her fake social media, so that as a consequence, she has been a suspect of a breach of a non-disclosure agreement in Apreplia's laboratory. Hence, Ms. Verman visited Ranovskaya's consular to grant it an asylum, and Ranovskaya hold her and refused to hand over Ms. Verman to the Apreplia's authorities. Thus, this is the pioneer why Ranovskaya violated international law by not surrender Ms. Verman. Your Excellencies, Ms. Kambak Verman is a fugitive from Apreplia's justice, and there's no good faith and reciprocity from Ranovskaya to surrender her. As known, Miss Kambak Verman, with her own free will and consciousness, sees committed her domestic law by bound the non-disclosure agreement in the NBL. NBL itself is a national bioresearch laboratory that's owned and that's run by Aprepulia that located in the Segura province. And all employees has agreed as a condition of employment that they will not disclose or divulge any information in the laboratory. And the violation of this agreement is undertaking a possible prosecution. Your Excellencies, because of that, Apropria has formally asked for extradition and with the procedure as how international law regulated. And as known, there is no rule of international law which prevent the states from extradition their citizen from the other country. And in many practice states, that national legislation provides for the possibility of extradition without pre-existing the agreement. As these have in compliance with two cases that I will bring on the table, Your Excellencies. First, there's a cases of Mr. Safarkar, who is a Britain Indian nationality that was tried to escape from the justice of the British to France. Then the French hand over hand over him to the British authorities because consider he is clearly fugitive from British justice, Your Excellencies. Before British and French do the pre-existing of the agreement of extradition itself. And the second case is Maria Pauline's case, who is a committed 1.7 trillion rupiah bank burglary in Indonesia. She escaped from Indonesia to Serbia and got extradition because Serbia considered that Maria is clearly fugitive from Indonesia's justice. Thus, that is why Ranoksta has to do the reciprocity to Apropria by hand over Ms. Furman, but clearly this principle was not shown by Ranoksta, Your Excellencies. Precisely, on 8 June 2019, Apropria has sent a public statement to Ranoksta Consulate to hand over Ms. Furman, but Ranoksta still refused to do that, Your Excellencies. May I continue my argument?
Yes, please.
Your Excellencies, in the case of granting asylum to individual who comes in singly either because political persecution or having a committed common crime, the consideration of the receiving state that must taken of that state is what will be the fate if that person is pushed back to their origin state, because as known as an asylum is only give to the people that possible to get an inhuman punishment such as death punishment or any cruel punishment itself. And moreover, Ms. Furman is not being sentenced to death or get a cruel punishment. However, in a clarification of statement of facts, number 4, consider the violation of a non-disclosure agreement is only imprisonment for 1 to 20 years. Thus, Ranoksta did not have any obligation to accepting her, and by granting her asylum is clearly interference appropriate domestic affairs, Your Excellencies. Your Excellencies, asylum in the premises of a diplomatic mission is also violate international law, because based on Article 55 of paragraph 1 in VCCR, Ranoksta as a sending state ought to enjoy the privilege and immunities of the receiving state, which is Aprepuya, and Ranoksta also have a duty not to interfere the internal affairs of the receiving state. This is strengthened in paragraph 2 stipulates the consular premises shall not be used with incompatible manner of the exercise of a consular function, because as known, consular function is only comply with the representing, protecting, negotiation, ascertaining, and promoting friendly relations as laid down in the Article 3 of VCCR. Thus, Ranoksta clearly violated this international agreement and therefore should expel Ms. Verman to the Aprepuya because she's not fit with the criteria to be called as a refugee or asylum that should be protected by the other country, Your Excellencies. Your Excellencies, Ms. Kambak Verman is not an Ms. Kambak Verman is not fit with the criteria to be called as asylum or refugee seeker. To summarize, Your Excellencies, the first and the second submission, Aprepuya has respectfully required the court to declare that Run-of-Style violate international law by applying anti-regulation, so must compensate the resulting economic losses. And furthermore, we require the court to declare that Run-of-Style also violate international law by refusing to hand over misfirmament to the appropriate authorities. Thank you, Your Excellencies.
You're welcome. For the second applicant, you may proceed your pleading.
Thank you, Your Excellencies. Very good evening, Your Excellencies, Mr. President and the judges, Ms. Haura, and the agent of the Democratic State of Ranopstayu. My name is Ayu Anggraini, and I have the honor to appearing before this court appealing on behalf of applicant, the United States of Aprepuria, representing the case concerning COVID-19 pandemic. Your Excellencies, I will be delivering the third submission regarding to the court may not exercise jurisdiction over Ranoptayo's counterclaim concerning the maintained airways aircraft. And for the fourth submission regarding to even if the court were to exercise jurisdiction, Aprepuria did not violate international law by shooting down the maintained airways aircraft. With your permission, may I please the court?
Yes, please.
Your Excellencies, I will begin from our third submission. In this submission, I will be dealing with two main points. Firstly, the court may not exercise jurisdiction over Ranoptayo's counterclaim based on the Aprepulia's declaration reservation on declaration of Aprepulia and Ranoptayo 7 January 2002 and 10 March 2003. And for the second main point, the maintained airways aircraft is the domestic jurisdiction of the United Republic of Aprepulia. If you don't mind with the structure, I will continue, Your Excellencies.
Yes, please.
Your Excellencies, the problem started in the early morning of 26 June 2018, when a maintained airways aircraft are crashed into a territory in Aprepulia. Maintained Airways aircraft is a low-cost charter airline privately owned by Aprepulia nationality, and this aircraft is registered in Aprepulia authorities, Your Excellencies. The Maintained Airways aircraft are shooting down by Aprepulia military activities in order to prevent a tragedy regarding from the surveillance of the FOG's attack in Aprepulia's territory. And FOGs known as the terrorist organizations since 2016, Your Excellencies. And the Maintained Airways aircraft had taken off from Segura Airport without authorizations, and it was flying near capital city of Aprepulia. And as the result, the Maintained Airways aircraft are shot down and killed both the passenger inside the Maintained Airways aircraft, known as Mrs. Combat Foreman and Mrs. He as the pilot. And Aprepulia, on 16 July 2018, Ranoptayo notified the court about the wish to file a counterclaim, asserting that the shutdown of the Maintained Airways aircraft are violated international law. And under 2 days later, Aprepulia noted its intention to the court that the court may not exercise jurisdiction over the Ranoptayo's counterclaim concerning the Maintained Airways aircraft, Your Excellencies. Here, to prove that the court may not exercise jurisdiction, Aprepulia state that the court may not exercise jurisdiction based on the Aprepulia's reservation of declaration of 7 January 2002 and 10 March 2003, Your Excellencies. Your Excellencies, the dispute concerning Maintained Airways is fully authority of Aprepulia to solve it. Because whoever in their counterclaim, Ranoptayo claim about the court has jurisdiction over the shooting down the aircraft, but Aprepulia and Ranoptayo has declaration and reservation on 7 January 2002 and 10 March 2003. The court also has jurisdiction measures provided for in treaties and conventions as Aprepulia's violated international law in Chicago Convention. But Your Excellencies, moreover, the court has no jurisdiction based on the Aprepulia's reservation on the declaration of 7 January 2002 and 10 March 2003, Your Excellency.
And
Your
may I
Excellencies,
ask you a question? Can you hear me?
yes, Your Excellencies.
When you're shooting down the aircraft, did you know is that as a preventive action?
Yes, Your Excellencies, I understand your concern. When shooting down the maintained aircraft, we do an preemptive actions by sending the information and the visual code to the pilot of the maintained aircraft. And we also do an preemptive action in order to pre- to prevent prevent the use of force of the military authorities. But the maintained aircraft has not respond to our jet fighter and also to our Air Force, Your Excellencies. And in another hand, we also doing an preemptive action by sending the visual code to the pilots, but has no any response from the maintained aircraft, Your Excellencies.
But on
May I
26
continue?
June, but on 26 June 2018, the pilot is already gave a message to the aircraft.
Yes, Your Excellencies, I understand your concern. To be known that the maintained aircraft are not fit for the flight plan, Your Excellencies, and the maintained aircraft also did not send the information to the ATC at the appropriate authorities, and this aircraft was flying illegally, Your Excellencies. Uh, to be known that before the FOGs has already sent appropriate the inscription message and information that the FOGs will do an attack to appropriate authorities, Your Excellencies, and that reasons we need to take an action to shoot down the maintained aircraft, Your Excellencies.
So,
May I
so in
continue?
this case, did you already obtain or receive any information from the pilot or not in this case?
Yes, Your Excellencies, I understand your concern. Here, our jet fighters already give the preemptive action and uh, prevent the use of force to the maintained aircraft. And abruptly, Air Force had shot down a civilian aircraft headed in the direction of Bhutan. The aircraft had taken off from Sogra Airport without authorization. And abruptly, fighter jets piloted by highly trained and decorated Air Force officer piloted by highly trained. We follow internal and international regulation to the letter in the warning of the aircraft, Your Excellency. We also shoot down the wings of the root of wings of the maintained aircraft, and we we do not hope that the maintained aircraft will shooting down and crash into our territory, but we just hope that the maintained aircraft are landing by emergency, Your Excellency.
So my simple question
May I
is,
continue?
did you already obtain or receive any message from the pilot or not?
Yes, Your Excellencies, we didn't uh, receive any message and also information from the pilot because the maintained aircraft are flying illegally and did not giving information first to our ATC, Your Excellencies.
Okay, you may continue, Agent.
Yes, Your Excellencies. And here, based on the appropriate declaration of 7 January 2002 and 10 March 2003, and also relate to the Vienna Convention on the Law of Treaties 1969 in Article 2(1)(d) that regulate about the reservation as both Aprilia and Ranov Sayo has already binding on the declaration of 7 January 2002 and 10 March 2003. And Aprilia and Ranov Sayo also regarding to the Article 26 of the PCLT on the Pacta Sunt Servanda principle, Your Excellencies. And on their reservations, Aprilia claim that uh, this declaration shall not apply to any dispute regarding to the appropriate military activities and also uh, regarding to the appropriate domestic jurisdiction as what appropriate government determine, Your Excellency. And the maintained aircraft are linked to the military activities and also linked to the appropriate domestic jurisdiction, Your Excellency. So the court has no jurisdiction over the maintained aircraft based on the Declaration of Reservation of Aprapulia and Ranop Sayu 7 January 2002 and 10 March 2003, Your Excellencies. As in several cases that linked to the reservation that made by United Nations, and also regarding to the case concerning fisheries jurisdiction Spain versus Canada, that the court adjudged and declared that the International Court of Justice has no jurisdiction based on this reservation. And also regarding to the amendment currently that made uh, by the Mexico, Liberia, Pakistan, South Africa, and France, as following the United States invoked the amendment as one of their national regulation that has become precedent in their country, Your Excellencies. And for moving to our second main points regarding to the maintain airways aircraft dispute is the domestic jurisdiction of the United Republic of Aprapulia. Your Excellencies, this consider to the Article 2, Paragraph 7 of Charter of the United Nations that stated its domestic jurisdiction as said is the competence of a country to fully exercise its sovereignty without interference from other parties or countries, even though international law, Your Excellencies. And also strengthened by the Article 15, Paragraph 8 of the League of Nations and Article 5 of the Convention of the Suppression of Unlawful Acts Against the Safety of Civil Aviation 1971, Your Excellencies. And the dispute involving maintained airways aircraft in the as the previously is the same in the Lotus case that used the territorial principle by the International Court of Justice, Your Excellencies. Here, the maintained airways aircraft is the domestic jurisdiction of Aprapulia based on the territorial principle and based on the sovereignty of Aprapulia as a state, Your Excellencies. This regulate in the Article 1 of Chicago Convention that the contracting state has recognized that every state has complete and exclusive sovereignty over the airspace above its territory, Your Excellencies. And this principle that one sovereign state cannot exercise jurisdiction over another sovereign power, and is the basis of Ranov Tayo cannot interfere the Aprapulia's interest in this case of maintained airways aircraft, Your Excellencies. And to sum up, that the court may not exercise jurisdiction over the maintained airways aircraft or because the reservation of 7 January 2002 and 10 March 2003, and because the maintained airways aircraft are the domestic jurisdiction of the United Republic of Aprapulia, Your Excellencies. Your Excellencies, moving to our fourth submission regarding to the court, even if the court were to exercise jurisdiction, Aprapulia did not violate international law by shooting down the aircraft. Your Excellencies, here I will be dealing with three main points regarding to the court were to exercise jurisdiction. Aprapulia did not violate international law by shooting down the aircraft. First, Aprapulia did not violate international law by shooting down the aircraft. And second, the maintained airways aircraft was flying illegally and to the Aprapulia's capital city. And third, Aprapulia's good faith to comply the standard operating procedure, Your Excellencies. If you don't mind with the structures, I will continue our argument, Your Excellencies.
Yes, ma'am.
Thank you, Your Excellencies. Aprapulia did not violate international law by shooting down the maintained airways aircraft. This accident of maintained airways aircraft that shooting down by the military of Aprapulia is about domestic jurisdiction of Aprapulia. And also the maintained airways aircraft shooting down by the Aprapulia's military authorities are already complied to the standard operating procedures, which is under the domestic law of Aprapulia and also under the international law, Your Excellencies. Here, there is no reason Aprapulia violates international law provisions, since state sovereignty of Aprapulia that has this authority of Aprapulia's institution and Aprapulia human rights interests, Your Excellencies. Based on the state sovereignty of Aprapulia that has this authority of Aprapulia's institution, as stated that the international responsibility can be applied to Aprapulia since there is no an internationally wrongful act that Aprapulia entails its international responsibility that committed by the case concerning of maintained airways aircraft, Your Excellencies. And the convention relating to the regulation of aerial navigation on the Article 1 that regulates complete and exclusive sovereignty over the airspace of states' territory, Your Excellencies. This is also in turn with Article 1 of Chicago Conventions that stated the contracting state has recognized every state has complete and exclusive sovereignty over the airspace above its territory, Your Excellencies. And here, based on the appropriate state sovereignty, Apropria has the right and fully authorities to protect their citizens by take action shooting down the maintained airways aircraft, Your Excellencies. Because in the Convention of International Civil Aviation 1944, it stated in each contracting state may, for reasons of military necessity or public safety, restrict, prohibit uniformly the aircraft of other states from flying over certain areas of its territory, Your Excellencies. And the action of Apropria by shooting down the maintained airways aircraft are linked to these provisions under the Chicago Convention 1944, Your Excellencies.
But
And hinge
Agent, you
the
said that
principle of
you already
yes,
said
Your
that there
Excellencies.
is military necessity in this case. Can you give the definition of the military necessity? Is it same with the preemptive actions of the military necessity?
Yes, Your Excellencies, I understand your concern. The military activities and the military necessity that took by appropriate authorities are linked to the self-defense actions, Your Excellencies. And here's based on the self-defense based on the self-defense theory that this principle is relevant to the scope of a state right to self-defense against an imminent attack by a state actions, and also states have the right of self-defense against an imminent or actual armed attack uh, by a state or non-state, Your Excellencies. And here the appropriate military authorities are linked to protect their civilian of appropriate and take the action to shoot down the military with aircraft. And also regarding to the appropriate air force that uh, one of the part of the military of Aprapuya show us that the maintained airways aircraft are linked to the military activities, and the action of the shooting down maintained airways by the fighter jet of Aprapuya Air Force are linked to the military activities, Your Excellency.
Was shooting down the miss or the asylum seeker? I forget the name of the asylum seeker. Fulfill the requirement of the military's necessity of the self-defense.
Yes, Your Excellencies. Regarding to the pilots and the passenger of inside the maintained airways aircraft, Mrs. Kemba Forman and Mrs. K are not linked to the necessity of the military, Your Excellencies. Uh, it's we prove that the Mrs. Kemba Forman is not fit for the to be called as asylum seeker, Your Excellencies. So there is no any kind of political interest or military interest by the nationality of and the status of the passenger inside it, but the actions and the reasons of the why the Aprapulias take action on shooting the limited airways aircraft, Your Excellencies.
Okay, you may continue, Agent.
Yes, Your Excellencies. And also, based on appropriate human rights that protected by Apropria is linked to the Universal Declaration of Human Rights, Article 3 stated that everyone has the right to live, liberty, and security of person, Your Excellencies. And every Aproprian has the right to live, liberty, and security from the threat of the aircraft along the territory of Apropria. And hence, the aircraft are valid to respond any kind of the communication from the Aprapuyan, and it was flying near capital city of Aprapuya, and it became a threat for the Aprapuya national Aprapuya civilian, Your Excellencies. And this airplane also assumes has the spy missions and bomb laden of the airplane as a weapon on national capital city of Aprapuya. And This action is clearly violated the human rights of Aprilia under the UDHR, Your Excellencies. And also, Aprilia's military authorities has linked to all the obligation and the rules of preemptive the use of force, Your Excellencies. As I said before, that the authorities of maintain airways aircraft did not directly shoot down the maintain airways aircraft, but doing an investigation and uh, by the Air Force of Aprilia, Your Excellencies, and for the reasons that the maintain airways aircraft are flying illegally near capital city of Aprilia, and this aircraft was do not do an ATC first and flight plan to the ATC of Aprilia authorities, and this uh, this and Aprilia are in the condition of the threat of the FOD's attack, Your Excellencies. And by that reasons, we need to take an action to shooting down the maintain airways aircraft. And in other hand, our country also comply to the standard operating procedure, Your Excellencies. And for the foregoing reasons, we we ask to the court to respectfully judge and declare that the maintain airways aircraft dispute is the domestic jurisdiction of Aprilia, and even if the court were to exercise jurisdiction, Aprilia did not violate international law by shooting down the aircraft. Thank you, Your Excellency.
Okay, for the first respondent, you may continue your argument, please. The first respondent.
Saya Kak.
Okay.
But wait for the timer from the applicant side. May I proceed, Your Excellency?
Yes, ma'am.
Very good evening, Madam President, Haura, Judge Ariwirya, agent of Aprilia, and the audience. Madam President and judges, my name is Arimbi Fajari Furkon. It is such an honor to stand in this virtual court pleading to represent the President of State of Ranostayo as the respondent in the present case concerning COVID-19 pandemic. I will be delivering the first and second part of respondent submission in the next 21 minutes, and my co-agent, M. Yusuf Akbar, will deliver the third and fourth part of respondent submission for 21 minutes, and we also reserve 3 minutes for jury battle. If you don't mind about the structure, may I proceed?
Yes, please.
The first submission is regarding to Ranostayo didn't violate international law by applying its anti-regulation to Aprilia. And even if it did, it should not be required Aprilia for any claim economic losses. Your Excellencies, there are three main arguments proving that Ranostayo didn't violate international law. The first, Ranostayo didn't violate international law because it was a state sovereignty of Ranostayo to apply the anti-regulation. And second, Ranostayo didn't violate international law by applying its anti-regulation to Aprilia according to the fundamental rights of person. And the third, Ranostayo has no obligation to compensate the economic losses. Now, with the court permission, I will turn to my very first argument regarding to the Ranostayo didn't violate international law by applying its anti-regulation because it was a state sovereignty of Ranostayo to apply the anti-regulation. Your Excellencies, there was confirmed case of COVID-19 pandemic in Aprilia had appeared from NBL on 10 April 2018. Aprilia didn't report the suspect person and failed handle it. Hence, in order to protect Ranostayo territory from that virus, Ranostayo made the anti-regulation which include the list of high-risk countries, where Apreplya was added to that list because the failure of handling that virus case in the NBL, and the travel restriction as a public desires and interest of Ranostayo. As a global community, Ranostayo cannot continue to ignore the acts of Apreplya to fail handling that virus. It must consider that Ranostayo didn't violate international law to obey the obligation of the state to protect our citizens for that kind of virus. Your Excellencies, the characteristics of the land of sovereign state is a competence exclusivity of the state regarding their own territory. The sovereignty of state is the same as their land and their airspace regarding to the Article 3 of the Montevideo Convention. Your Excellencies, Ranostayo has the rights and full sovereignty about how they want to regulate their country based on the regulation, as it fits for the interest and safety of their people. And this is what actually Ranostayo did regarding to the anti-regulation. It was for the safety of Ranostayan. Your Excellencies, the hesitance to recommend any restriction on international travel must be understandable, given the available evidence on the impact and long history of such measures being taken with little or scientific justification. With a travel ban, it may introduce potentially effective travel restriction to the goal of the international health regulation to prevent the spread of the public health threat. Your Excellencies, it reflects in the emergency health of Ebola virus 2014 until 2016. The travel ban was legally did as Australia became the first country to restrict the travel from the three West African countries at the center of the outbreak, and the act of Australia was lawful under international law. Your Excellencies, each state has the right to make any regulation depend on their needs of nation as good maintained and capable state to handle what they have to do in their territory. This statement also supporting by the domain reserve doctrine declared by Austin Hobbes, where the state has jurisdiction to do their capacity and free from the obligation and regulation of international law. It also emphasized under Article 13 of the Universal Declaration of Human Rights, in order what happened in the internal state, it's a domestic affairs of the state itself. It's also strengthened under Article 1 of the Chicago Convention, emphasized about the exclusivity sovereign state that every country has the right to close off the airspace above its territory from the commercial efforts carried out by the foreign country. Your Excellencies, the anti-regulation of Ranostayo is reflected of Ranostayo's state sovereignty to protect Ranostayan under the Universal Declaration of Human Rights. Ranostayo conclude, Ranostayo has the right to do what they have to do in their territory as long as the desires and interests of Ranostayo. Worse, Ranostayo want to prevent COVID-18 virus to enter the state, and especially to all Ranostayan both inside and outside Ranostayo state. The principle of protection is carried out by the Ranostayo as an exercise of Ranostayo jurisdiction on the basis of the protecting the vital interests of the state. Moving to my second argument.
But agent, one question. But in this case, you refuse the World Health Organization recommendation. So is it true? Is it true or not?
Yes, Your Excellencies, I do understand your concern. Yes, it is true. Your Excellencies, the recommendation from the WHO is about the ban the travel restriction under the Article 15 of the International Health Regulation. But Your Excellencies, in the International Health Regulation under Article 1, it also stipulates that the kind of terms of the Article 15 is a kind of non-binding advice to the member of the WHO. It can be concluded that this recommendation is not legally binding as a treaty legally binding to the state, Your Excellencies. So the Ranostayo conclude we have to choose what the important to us, and we choose to protect our citizens and apply our anti-regulation or our anti-restriction to the other country to prevent the COVID-19 virus to our territorial. May I
So,
continue?
so can you convince us? Can you convince the court that the harm by the entry restriction outweigh the benefits of the entry restriction?
Yes, Your Excellencies, the benefit of our entry regulation itself is is more effectively to our to our territorial about the prevent to the COVID-19 virus, since there is no cases in the Ranostayo when we apply the anti-regulation to our territorial excellencies. And for the example, the Aprepuya country at the end had cases of COVID-19 up to 2,000 cases in the Aprepuya by didn't apply the anti-regulation. And in the Ranostayo territorial is just 30 cases exist in the Ranostayo. It from the Ranostayan outside the Ranostayo territorial itself, Your Excellencies. May I continue?
Yes, Agent, please.
Yes, Your Excellencies, moving to my second argument, Ranostayo didn't violate international law by applying its anti-regulation to Aprepuya according to the fundamental rights of person. Under Article 25 of the Universal Declaration of Human Rights, it explained the right to live, secure, and healthy for the person, which that rights are fundamental rights and also a kind of natural rights relating to the natural law, natural rights, river, to that rights are universal to international community. And Your Excellencies, regarding to the Salus Populi Suprema Lex Esto principle, that the safety of our people is the highest law. It can be concluded that Ranostayo consider that many Ranostayos citizen vacation to the Aprepuya, and Ranostayo tried to protect its citizens both inside and outside the Ranostayo country. It also takes into account the international protection and security during a pandemic. Your Excellencies, moving to the next page, Ranostayo has no obligation to compensate the economic losses because Aprepuya didn't confirm and notified WHO about the employers in NBL are infected by the COVID-19 virus. Your Excellencies, under International Health Regulation, Article 6, Paragraph 1, I quote, each state party shall notify WHO assessment of a public health information of all events which may constitute a public health emergency of international concern within its territory. Thus, Aprepuya didn't respect the international law by didn't report the suspect person in the NBL by the COVID-19 to WHO first. Also, Aprepuya hide this information, and Ranostayo government disappointed because there's so many Ranostayan in Segura province. Therefore, Aprepuya shall be referred to the International Court of Justice in conformity with the statute of the court as a consequence concerning not under WHO Constitution under Article 75 WHO Constitution. Your Excellencies, may I continue to my second submission?
Yes, please.
The second submission is regarding to Ranostayo didn't violate international law by refusing to hand over Ms. Kenbak Formun to the Aprepuyan authorities. Your Excellencies, there are three main arguments proving that Ranostayo didn't violate international law. The first, extradition law can prohibit Ranostayo to hand over Ms. Kenbak Formun to Aprepuya from her political offense. And second, the human rights of Ms. Kenbak Formun was protected by international law. And the third, Ms. Kenbak Formun information protects public interest. Your Excellencies, Ms. Kenbak Formun is Aprepuya national born and raised in Segura province. She is the NBL member and signed the NBL non-disclosure agreement. On 10 April 2018, may I introduce you, Your Excellencies, what is NBL is. NBL is a public laboratory handled by the government of Aprilia to project the vaccine of the COVID-19 cases. Your Excellencies, on 3 June 2018, Ms. Kenbak Forman sent the information of disclosure about the COVID-19 cases in Aprilia. Through her Twitter, she created the government of Aprilia keep denying about the cases that already exist. According to her post, the Aprilian police chased her and she drove through the front gates of Ranostayo Consulate in Segura province. At that time, the consul agreed to let she stay in unused room in the consulate building and become an asylum seeker of Ranostayo. I will proceed to my very first argument, Your Excellencies, regarding to extradition law prohibit Ranostayo to hand over Ms. Farman to Aprilian from her political offense. The act of Ms. Kenbak Forman was categorized as a political offense since she against the government of Aprilia through her Twitter, prejudiced her state system of information of COVID-19. The cases of COVID-19 in Aprilia was had by the government in Segura province. So Ms. Kenbak Forman against her government to say the truth about the cases of COVID-19 and also against the government by didn't obey the agreements between employers and NBL about non-disclosure agreement. Your Excellencies, extradition cannot apply by the act of the political offense according to the Article 33(1) of the Convention and Protocol relating to the status of refugee and customary international law. The Article 33(1) stipulates, I quote, "No contracting state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his political opinion." Your Excellencies, both Aprilia and Ranostayo are the parties of the convention, and thereafter neither Aprilia and Ranostayo have the reservation about the terms of this article. Further, according to the Model Treaty on Extradition adopted by the General Assembly Resolution 45, under Article 3, mandatory grounds for refusal extradition to the political offense, and if the requested has substantial grounds for believing that the request for extradition has been made for the purpose of persecuting or punishing a person on account of that person's race, religion, nationality, ethnic origin, and political opinions. Ms. Kenbak Forman, who did the political offense, must be not handed over to Aprilia by Ranostayo, because according to the UN regulation that I mentioned before, Ranostayo cannot expel her and she cannot be returned to Aprilia. Thus, Ranostayo as a state, respect to the international law, protects her life from the prosecution of Aprilia. It was also drawn by the case of Edward Joseph Snowden is one of the reflection of protects the asylum from the political offense. Your Excellencies, also Pan-American Convention on the Territorial Asylum 1954 stipulates that extradition will not be granted if the determination of an asylum state surrender of the person concerned is being sought for the political offense for common crimes which have been committed for the political objective or for political reasons. Also, it's strengthened by the Brazilian case in Rede Bornenfeld illustrate the same point for the refusing the extradition of a fugitive charged by the French government with having participated. To conclude, Ranostayo believed that Aprilia had a purpose to persecute Ms. Kenbak Forman because of her information about the cases of COVID-19 in NBL, Your Excellencies. It has considered to the international law to refuse extradition from the political offense. Your Excellencies, may I continue to the next argument?
Yes, please, Agent.
Thank you, Your Excellencies. Going to the next argument, the human rights of Ms. Campbell Foreman was protected by international law. Your Excellencies, human rights is the fundamental right since being human is considered to the United Nations purpose about humanity. The international law instruments support the human rights are as a universal declaration of human rights under Article 2, Article 3 about the rights to life and security for the person. Moreover, under Article 14 regulates about the rights to seek and enjoy in another country asylum from the persecution. As a person, Ms. Kenbak Formun has the right to enjoy and seek the asylum from the Ranostayo as long as Ranostayo accepts and protects her from Aprepuya. Furthermore, the Convention for the Protection of Human Rights and Fundamental Freedoms under Article 10 about the freedom of expression, Ms. Kenbak Forman posts the information about her country related to the case of COVID-19 that categorized as a pandemic by the WHO. It can be said, the reflecting of her right to freedom of expression of important information. Hence, Ranosai respect to the human rights to protect Ms. Kenbak Forman as human being. The information of Ms. Kenbak Forman is reflection of protecting human rights since she was against the government of her country, the safe of the people of Aprepuya to live secure and health.
Agent.
Yes, Your Excellencies.
Yes, Ms. Foreman has the right for seeking an asylum in consulate or diplomatic representative office in provider country in applicant's country in this case.
Yes, Your Excellencies, I do understand your concern. Your Excellencies, actually, Ms. Kenbak Formun didn't apply the asylum seeker didn't accept it to our asylum seeker by our consul in the consulate itself. But your Excellencies, the application of the asylum seeker from Ms. Kenbak Formun was take over to our foreign ministry in the Ranostayo territory, Your Excellencies. It also have similarly state practice to the United States practice about the consul didn't have the jurisdiction to accept the uh, asylum seeker, but they can over the application of asylum seeker to our foreign ministry. Your Excellencies, my time is about to expire. Can I continue?
Yeah, yes, please.
Yes, Your Excellencies, for the foregoing reason, respondent respectfully requests to the court that finds it waiver to adjudge and declare that Ranostayo didn't violate international law by applying its anti-regulation to Aprepuya, and even if it did, it should not be required Aprepuya for any claim of economic losses, and Ranostayo didn't violate international law by refusing to hand over Ms. Kenbak Forman. Thank you, Your Excellencies.
Okay, thank you, Agent. Uh, for the second respondent, you may continue your pleading, please.
Thank you, Your Excellencies, and very good evening, Your Excellencies, Madam President Haura, Judge Ari, and the agent of the United Republic of Aprepuya. My name is M. Yusuf Akbar. It is the honor to appear before this court, representing on the behalf of the democratic state of Ranabstayo as respondent in this case concerning to the COVID-19 pandemic between Aprepuya and Ranabstayo, where I will speak for the next 21 minutes, and I will be addressing our third and fourth submissions regarding to the court may exercise jurisdictions over an abstaining counterclaim concerning the maintenance of aircraft and Aprepuya violated international law by shooting another aircraft. Your Excellencies, if you don't mind about the structure, may I proceed to my arguments?
Yes, please.
Thank you, Your Excellencies. Your Excellencies, the problem emerged when Ms. Furman, who already an applicant for asylum seeker, Suran Abstayo, is intended to manage to get away from the territory of Aprepuya. But, Your Excellencies, in the process, her airplane was shot down by the Air Force of Aprepuya. The reason to do that is because they believe that airplane was used for committing terrorist actions. But Your Excellencies, based on the recording crash of the airplane, we can conclude from the conversations of Miss Perman and Miss Wei, they never intended to use that airplane for terrorist actions, rather than they only want to get away from the territory of Aprepuya. Because of this, Your Excellencies, in our third submissions, we declare that the court may exercise jurisdictions over an abstio counterclaim concerning the Maintain Airways aircraft. Your Excellencies, in these submissions consist of two main arguments, where in the first argument, the court has jurisdictions under Article 36 Statute of the International Court of Justice, and in the second argument, the court has jurisdictions over an abstio interest on the counterclaim. Your Excellencies, in our first argument, the court has jurisdictions under Article 36 Statute of the International Court of Justice, where under Article 36, Paragraph 1 Statute of the International Court of Justice, where it provides, I quote, the jurisdictions of the court comprises all cases which the parties refer to it and all matters specially provided for it in the Charter of United Nations or in treaties and conventions in force, unquote, where Your Excellencies, based on the statement of facts on 17 August 2020, both Aprepuya and Anabstayo agree to have this dispute to proceed in the ICG, and this is already fulfilled based on the criteria according to the Article 36, Paragraph 1 Court Statute. Moreover, Your Excellencies, the court may also be granted jurisdictions over dispute arising from international treaty, where such treaties contain a compromissory clause. Providing for this, in fact, Your Excellencies, quite a large number of international treaties, both bilateral and multilateral, do include a clause awarding the ICJ jurisdictions with respect to the question that might arise from the interpretations and application of the agreements. Your Excellencies, the court has jurisdictions based on the declarations of Aprepuya and Ranabstayo on 7 January 2002 and March 2003, where Aprepuya and Ranabstayo at that time respectively deposit declarations with the Secretary General of the United Nations under Article 36, Paragraph 2 of the Statute of the ICG. Both declare that accepting ICG jurisdictions as compulsory jurisdictions ipso facto and without special agreement. If the court, Your Excellencies, does not have jurisdictions because of some reservations, it may still have jurisdictions on another basis. Limitations on the court jurisdictions under a compromissory clause, but not in the declarations, does not affect the declaration itself. Moreover, Your Excellencies, Article 93, Paragraph 1 of the Charter of the United Nations, I quote, all members of United Nations are ipso facto to the parties to the Statute of the International Court of Justice. Your Excellencies, the court also has competence to determine the meaning of its own jurisdictions and interpret the term of the relevant compromise or the relevant treaty or declarations it deems appropriate in these circumstances, where the court discussed that nature of such declarations regarding to the interpretations in the Cameron v. Nigeria, Your Excellencies. Moving to my second argument, Your Excellencies, the court has jurisdictions over an abstio interest on the counterclaim. Your Excellencies, the court has jurisdictions regarding to the Ranabstio's counterclaim over shooting down the Maintain Airways. As stated on the Article 36, Paragraph 2, the court also has jurisdictions regarding to the legal dispute concerning the interpretations of a treaty, any question of international law, the existence of any fact which, if established, will constitute a breach of an international obligations and the nature or extent of the reparations to be made for the breach of international obligations. In this case, Your Excellencies, Aprepuya has fulfilled the clause any question of international law, the existence of any fact which will constitute a breach of an international obligations. The fulfillment of this clause are based on the Ranabstayo interest over their counterclaim, where Your Excellencies, Aprepuya has violated international law by shooting down the Maintain Airways, because Your Excellencies, the actions of shooting down the Maintain Airways are violated the Chicago Conventions, especially in the Article 3 bis A, where it states that each state must refrain from using weapons against civilian aircraft. Moreover, Your Excellencies, the Aprepuya actions on shooting down the Maintain Airways is also violated Article 2, Paragraph 4 of the Charter of the United Nations, a state that prohibit all the use of force. And Your Excellencies, in the Article 1 state that every internationally wrongfully act of a state
Okay.
entails the international responsibility of that state, Your Excellencies. Apripulia actions towards
Agent,
shooting, yes, Your Excellency.
uh, can you prove that the applicants fail to fulfill requirements in Article 51 of the United Nations Charter of the Self-Defense to use of force?
Yes. Yes, Your Excellencies, I understand your concern concerning the how we prove why the Apripulia violated international, especially in the charter, because Your Excellencies, Kofi Annan, in the case of the invasion of Iraq from the United States of America, he stated that the every country must hold or upheld the highest charter of Article 2, Paragraph 4, Charter of the Nations regarding the non-use of force, because, Your Excellencies, the legality of use of force is only legal when that state is become the victim of the actions of the from the use of force itself. So, Your Excellencies, if let's just say that Apripulia has already become the victim of the imminent threat of terrorist actions, not based on the preemptive attack, then yes, that legality of use of force can be lawful. But in this case, Your Excellency, sadly that Aprilia actions towards shooting down the mainland airways is already based on their assumptions, and that assumption is clearly danger regarding to the human life. And because of this, moreover, that Aprilia assumption is not based on the solid evidence, rather than based only from their assumptions of so-called imminent threat of terrorist actions, but it turns out to be false. So that's why, Your Excellencies, we believe that Aprilia committed and violated the use of force as stated in the Charter of the Nations, Your Excellencies.
Okay, Jen, you may continue your pleading.
Thank you, Your Excellencies. Your Excellencies, moving to our fourth submissions regarding to Aprilia violated international law by shooting down the aircraft. Your Excellencies, every civilian aircraft is under protections of the Chicago Conventions. The actions that was taken by Aprilia to shooting down the Mainland Airways aircraft is indeed violated international law based on the Article 3 bis, as I mentioned before. And that's why, Your Excellencies, allow me to deliver you our arguments in these four submissions, which consists of two main arguments, where in the first argument, Aprilia is violated international law for shooting down the Mainland Airways, and in the second argument, the right to life of every person on board of the Mainland Airways. Your Excellencies, in the first argument, Aprilia is violated international law for shooting down the Mainland aircraft because there are prohibitions of using air forces against civilian aircraft, where, Your Excellencies, the prohibitions of armed forces against civilian aircraft follows an international norm. Until 1928, the use of force was a natural component of the state's sovereignty. That year, the Kellogg-Briand Pact became the first conventions, Your Excellencies, to establish the non-use of force as a principle regulating international relations, a rule that taken up by the Charter of the United Nations and upheld by the International Court of Justice, Your Excellencies. Most of the legal theory thus consider that the non-use of weapons as a peremptory norm of international law, also called ius cogens. Your Excellencies, this principle has an impact on a civil aviation to the extent that a state may not use armed forces against commercial aircraft, Your Excellencies. An addendum to Article 3 bis A of the Chicago Conventions tell us that every state must refrain from the using of force against civilian aircraft. Moreover, Your Excellencies, the United Nations General Assembly took up the conventions precisely by asking all states to take the necessary steps to avoid incidents involving attacks on a civil aircraft that accidentally stray from their fixed route. Similarly, Your Excellencies, the International Civil Aviation Organizations, or ICAO, on several occasions has upheld the principle of protecting civil aircraft, where the Assembly at that time, I quote, condemns all acts of violence which may be directed against aircraft, aircraft crews, and passengers engaged in international air transport, unquote. Also, Your Excellencies, the United Nations Security Council Resolutions number 1067, I quote, condemns the use of weapons against civil aircraft in flight as being incompatible with elementary considerations of humanity, the rules of customary international law as codified in the addendum to Article 3 of the Chicago Conventions, unquote. Additionally, Your Excellencies, in order to make the principle of the non-use of weapons more effective, the Chicago Conventions provide for launching an investigation in case of the destruction of civilian aircraft. Although, Your Excellencies, based on the statement of fact that Aprilia still managed to investigate that the crash of Maintian Airways, but the recording of the plane shown that the passenger of Maintian Airways is clearly not intended to use their aircraft as a terrorist actions, rather than just want to get out from the Aprilia airspace. This is clearly, Your Excellencies, degrading of the human rights of the person in board, and the actions that was taken by Aprilia is frivolous. Next, Your Excellencies, in the second argument, the use of lethal force against Maintian Airways is excessive. Your Excellencies, allow me to tell you why the use of lethal force against Maintian Airways is excessive, because there is comparison case regarding to these issues, where the most significant of these are the Brothers to the Rescue case, in which Cuban forces shut down a small civilian plane that had allegedly violated Cuban airspace, and also the case of the Nachova Free Bulgaria, in which persons who were absent without leave from the army were shot while trying to escape. This case, Your Excellencies, did not concern events in situations of armed conflict and peaceful time, because of this, Your Excellencies, this proportionality principle will apply at all times. The finding that the use of lethal force was excessive was explained in the Nachova case judgment in the following terms. I quote, Your Excellencies. There can be no necessity to put human life at risk where it is known that the person to be arrested poses no threat to life or limb and is not suspected of having committed a violent offense, even if a failure to use lethal force may result in the opportunity to arrest the fugitive being lost. Unquote. Moreover, Your Excellencies, the Maintian Airways is a civilian aircraft, not a state aircraft, and it must be considered as non-threat, even if Aprilia deemed as a threat to their nations, Your Excellencies. Aprilia only play based on their assumptions, and such assumptions is danger in the case when the lack of the evidence. Also, international law never universally accepts to recognize based on the preemptive attack, and thus, Your Excellencies, Aprilia actions to use lethal force is excessive and must be responsible at all costs. Your Excellencies, to summarize my four submissions in the first argument, I will tell you the case about the shooting down of the American C-47 aircraft on 9 August 1947, where at that time President Joseph Broz Tito wrote a letter that more or less subsequently agreed on humanitarian grounds and with an explicit denial of responsibility to pay $30,000 to the families of each of the 5 crewmen that died in the August 19 incident. While likely unintentional, Your Excellencies, President Tito established a baseline for comparison on these issues. Surely, if an unarmed military transport should never be fired upon, it is even more reasonable that a country should never fire on a civilian aircraft, Your Excellencies, and thus Aprilia should never fire upon civilian aircraft in the very first. Therefore, must be responsible to the family of Miss Verman and Miss Ye for any kind of reparations. Your Excellencies, I will move to my second arguments, which is the right to life of every person on board of Maintian Airways. Your Excellencies, everyone have the right to not to be arbitrarily deprived of life. For that, the life of Miss Verman and Miss Wei must be preserved at all costs. The actions that was taken by Aprilia for shooting the Maintian aircraft is violated Article 6 of the International Covenant on Civil and Political Rights, or ICCPR, and therefore Aprilia must be responsible at all costs. Your Excellencies, the right to life, according to the Article 6 of the ICCPR, it provides that, I quote, every person has the right not to be arbitrarily deprived of life, unquote. And from that article, Your Excellencies, impose a correlative obligations upon state parties to respect that right and to ensure that the persons subject to their jurisdictions are not arbitrarily deprived of their lives. Similar protections against arbitrary deprivation of life appears in many conventions, Your Excellency, such as the American Conventions on Human Rights, the African Charter on Human Rights, and the League of Arab States revised Arab Charter on Human Rights. Your Excellencies, Ms. Furman and Ms. Ye is the victim of the term security, like the term terrorism, is one that brings with it both theoretical uncertainties and considerable emotional baggage, and one must avoid allowing the use of broad terms, Your Excellency, such as security, to cloud our understanding of the substance of state duties in respect of the individual right to life in a purely law enforcement context. These duties are not significantly different in the context of a terrorist threat to the security from what they are in the normal times, Your Excellencies. Their content must always be considered in the context of not of labels, but rather of particular fact of situations. The point to be made here is that it is only in the context of protecting
But
self-right
agent,
or most particularly, yes.
did you think that the Miss Berman could be categorized as asylum seeker? If it's so, in this case, Miss Berman refused any protection from the respondent country.
Yes. Yes, Your Excellencies, I understand your concern. Yes, Your Excellencies, we believe that Ms. Furman is fit the criteria to be called as refugee because why, Your Excellencies? There is no clear criteria regarding to how someone to be fit of refugee. If there is it is only need if that person feel their life has been threat from their own country or their life has been or he or she has been believe persecutions. While from this, based on a statement of fact, Your Excellencies, that Ms. Verman come to the Consul of Ramestayo with information that so valuable to us because why? Considering that in the Segura province have many Ranopstayan who vacation there and the informations of Ms. Verman that state her government tend to secret of the possible JVID-18 outbreak is yes, we accept Ms. Perman considering the informations. And also, Your Excellencies, why we accept Ms. Perman? Because we have obligations under international law, especially on the Article 33, Paragraph 1 of the Convention on the Status of Refugee regarding to the principle of non-refoulement if someone believe their life has been threatened. So that's why we accept Ms. Furman, Your Excellencies, considering the information she gives to us, and considering also she feel the life of her has been threatened, Your Excellencies.
Even if the location of Miss Berman is in the receiving country or the applicant's country. So you can extend your the Miss Berman's asylum seeker's right to the receiving country.
Yes, can you repeat the question, Your Excellencies?
So you stated that you can extend the right of the asylum seeker, in this case Ms. Berman, to the receiving country or the applicant's country.
I'm sorry. Can you repeat?
So you stated that the respondent can extend the right of the Miss Berman as the asylum seeker in the applicant state.
Yes. Oh, yes. Yes, Your Excellencies, my time is up. May I need possible time?
Yeah, you can get the time
Okay.
about 1 minute.
1 minute. Okay. Thank you, Your Excellencies. Why? Yes, we believe that Your Excellencies regarding to extend the right of Ms. Berman to be our applicant for asylum seeker because Your Excellencies, we have the right as a sovereign state to accept or not to accept regarding to who become our asylum seeker. So in this case, Your Excellencies, Ms. Berman is actually our asylum seeker because our president has already approved Ms. Verman to be asylum seeker, and also to be considered that, Your Excellencies, even though that there is no law regulating the state to have an obligation to accepting people to become their asylum, but the many practice of a state in the international society tend to granting of asylum to any person who believe that their life have been threatened, because, Your Excellencies, they are rights of every individual to asking for asylum, especially regulated in the Article 14 of the Universal Declaration of Human Rights. And also to be considered that, Your Excellencies, when the misperman comes to us in the Council of Ranvastayo, it is actually become the extraterritorial sovereignty of the Ranvastayo itself. So yes, we have those rights regarding to extend the right of misperman, and the shooting down of the military areas is also, we believe, a contradict to our interests, Your Excellencies.
Oke, berarti komentar ya, Ra.
Boleh.
Silakan. Mungkin overall terus